My wife walked into the courtroom visibly pregnant, smiling like she'd already won. Her lawyer looked confident. Her family looked hopeful. But I had a vasectomy card in my pocket and one question ready, and I knew the judge would ask it before I ever had to. My name is Ethan Cole, and I am 36 years old, and I work as a paralegal at a corporate compliance firm where I spend most of my days reviewing documents and tracking timelines and identifying inconsistencies in business records that might indicate fraud or misconduct or regulatory violations that could expose my clients to legal liability. My professional training has given me a particular set of skills that most people would find tedious or overly meticulous, but which I have always found deeply satisfying because there is a certain clarity and certainty that comes from working with documented facts and time-stamped records and verifiable evidence rather than relying on the messy, unreliable territory of human emotions and subjective interpretations of events that people tell themselves in order to make their lives feel more coherent than they actually are. I had been married to my wife Vanessa for 11 years when the events I am about to describe began to unfold, and during those 11 years we had built what I thought was a stable and relatively content life together in a modest 3-bedroom house in a suburban neighborhood where the schools were decent and the neighbors kept to themselves and the mortgage payments were manageable on our combined incomes. Vanessa worked as an administrative assistant at a mid-sized logistics company that handled freight coordination and warehouse management for regional distributors, and while her job was not particularly glamorous or high-paying, it provided steady income and reasonable benefits and gave her a social environment where she seemed to enjoy the daily interactions with coworkers and the sense of being part of an organizational structure that valued her contributions. We had 3 children together who ranged in age from 8 years old down to 4 years old. And after our 3rd child was born, I had made the decision to have a vasectomy because Vanessa and I had agreed that 3 children were sufficient for our family size and our financial capacity and our ability to provide adequate attention and resources to each child without stretching ourselves too thin. The vasectomy procedure had been straightforward and uncomplicated, and I had received a written confirmation letter from the urologist approximately 2 years ago stating that the procedure had been successful and that follow-up testing had confirmed that I was no longer capable of producing viable sperm that could result in pregnancy. I kept all of our important medical documents and financial records and legal papers organized in a fireproof safe in my home office, which was really just the converted 3rd bedroom that I had claimed as my workspace where I could review case files and update my continuing education certifications and maintain the kind of systematic filing system that my professional work required. The safe contained birth certificates and social security cards and insurance policies and tax returns and mortgage documents and medical records, including the vasectomy confirmation letter that would later become the single most important piece of evidence in the sequence of events that transformed my marriage from a stable domestic arrangement into a public confrontation that would expose not just my wife's betrayal, but also the systematic misconduct of the man she had chosen to betray me with. The first indication that something was wrong came on a Monday morning when I was sitting at the kitchen table reviewing my work calendar on the tablet that Vanessa and I shared for household scheduling purposes. And while I was scrolling through the week's appointments, a notification banner appeared at the top of the screen reminding Vanessa about a prenatal clinic appointment that was scheduled for the following Wednesday afternoon. I stared at the notification for several seconds, trying to process what I was seeing and trying to generate some explanation for why my wife would have a prenatal clinic appointment when I knew with absolute medical certainty that I could not have been the biological father of any pregnancy she might be carrying. My first instinct was to take a screenshot of the notification before it disappeared from the screen, and I used the tablet's built-in capture function to save an image that showed the appointment date and time and the clinic name and the patient name, which was clearly listed as Vanessa Cole. I saved the screenshot to a secure folder on my phone rather than leaving it on the shared tablet where Vanessa might discover it, and then I closed the calendar application and set the tablet back down on the kitchen counter as though I had not seen anything unusual or concerning. Vanessa was upstairs getting ready for work, and I could hear the bathroom fan running and the sound of her moving around in our bedroom, and I sat at the kitchen table drinking my coffee and trying to maintain the same calm, composed expression that I had trained myself to display in professional situations where I needed to gather information and assess evidence before making any decisions about how to proceed. The paralegal work that I did for corporate clients had taught me that the worst mistakes people make when they discover potential misconduct are the mistakes that come from acting on incomplete information or from allowing emotional reactions to override careful, systematic investigation of the facts. I knew that I needed to verify my memory of the vasectomy timeline before I did anything else, and while Vanessa was still upstairs, I went into my home office and unlocked the safe and pulled out the medical records folder where I kept all of our family's important health documentation. The vasectomy confirmation letter was exactly where I remembered it being, filed in chronological order with other medical records from the past 5 years, and the date on the letter confirmed that the procedure had been performed approximately 2 years and 3 months ago, and that follow-up testing had verified successful sterilization approximately 3 months after the initial procedure. I used my phone to photograph the vasectomy letter with particular attention to capturing the date and the physician's signature in the laboratory results that confirmed the absence of viable sperm. And then I returned the letter to its proper place in the folder and locked the safe and went back to the kitchen to finish my coffee before leaving for work. Vanessa came downstairs a few minutes later, looking rushed and distracted as she usually did on weekday mornings when she was trying to get herself ready and also make sure that our oldest child had everything packed for school, and she asked me if I had remembered to sign the permission slip for our daughter's upcoming field trip to the Science Museum. I told Vanessa that yes, I had signed the permission slip and that it was in our daughter's backpack ready to be turned in to the teacher, and Vanessa nodded and grabbed her purse and her work bag and kissed me quickly on the cheek before heading out to her car in the driveway. I watched through the kitchen window as she backed out of the driveway and drove down the street toward the main road that would take her to the logistics company where she worked, and I found myself wondering how long she had been planning whatever deception she was currently engaged in, and whether she had any awareness that I had just discovered the first thread that would eventually unravel her entire constructed narrative. During my drive to work that morning, I began mentally constructing a timeline that would help me understand the scope of what I was dealing with, and I realized that if Vanessa was far enough along in a pregnancy to be having prenatal appointments, then the conception would have occurred sometime in the past 8 to 12 weeks, depending on exactly how far along she was. I made a mental note to check our shared calendar more carefully to see if there were any unexplained absences or suspicious patterns in Vanessa's schedule during that time frame, and I also began thinking about who I should consult for legal advice before I made any decisions about how to confront Vanessa with what I had discovered. I had worked with several family law attorneys through my job at the compliance firm because some of our corporate cases involved employment disputes that touched on personal relationship issues or custody arrangements that affected employee availability and performance, and I knew that one of those attorneys, named Marshall Kent, had a reputation for being thorough and strategic and focused on documentation rather than on emotional drama. I decided that I would call Marshall's office later in the week to schedule a confidential consultation where I could present the basic facts of my situation and get advice about what evidence I would need to gather and what legal options I would have once I was ready to move forward with whatever action seemed most appropriate. When I arrived at my office, I went through the motions of my normal work routine, reviewing compliance reports and updating case files and responding to emails from clients who needed guidance on regulatory documentation requirements. But throughout the day, I found my mind returning to the image of that prenatal appointment notification and to the implications of what it meant for my marriage and my family and the future that I had assumed was stable and predictable. I had always prided myself on being someone who could maintain focus and compartmentalize different aspects of my life so that personal concerns did not interfere with professional responsibilities. But I discovered that morning that there were some revelations that were simply too significant to be completely set aside even with the best intentions and the most disciplined mindset. During my lunch break, I sat in my car in the office parking lot and reviewed the screenshot I had taken of the prenatal appointment notification, and I also looked at the photograph of the vasectomy confirmation letter to verify once again that I had not somehow misremembered the dates or the medical findings. The evidence was clear and undeniable and left no room for alternative explanations that might allow me to believe that this pregnancy was somehow legitimately mine. And I felt a cold clarity settling over me as I realized that I was going to have to approach this situation with the same methodical documentation-focused strategy that I used in my professional work. I opened a new note file on my phone and began creating a simple chronological record of what I knew so far, starting with the date I had seen the prenatal appointment notification and the date of my vasectomy, and the approximate conception window that would be consistent with Vanessa's current stage of pregnancy based on the timing of the upcoming appointment. I knew from my work experience that contemporaneous documentation was crucial for establishing credibility and for preventing the kind of memory distortions that could occur when people tried to reconstruct timelines weeks or months after events had occurred, and I wanted to make sure that every step of my investigation was recorded with dates and times and specific factual observations, rather than with subjective interpretations or emotional reactions. That evening when I returned home from work, Vanessa was already there preparing dinner and helping our children with their homework, and I observed her carefully looking for any signs of guilt or nervousness or unusual behavior that might indicate she was aware that her secret was at risk of being discovered. She seemed completely normal and relaxed and engaged with the children in her typical way, and she asked me about my day at work with the same casual, friendly tone she always used during our evening routine. I provided brief, neutral answers about meetings and case reviews and deadlines, and I asked her about her day at the logistics company and whether anything interesting or unusual had happened. Vanessa told me that her day had been mostly routine, except that there had been some kind of HR investigation announced at work that had made everyone nervous, because apparently someone had filed a complaint about inappropriate workplace relationships, and the company was taking it seriously enough to bring in an outside investigator to interview employees. She said this information in a casual, conversational way, as though it was just interesting office gossip rather than anything that had personal significance. And I made a mental note of the comment because I wondered whether there might be some connection between this workplace investigation and whatever situation Vanessa had gotten herself involved in. The family dinner took place on a Thursday evening, 3 days after I had first seen the prenatal clinic appointment reminder on our shared tablet, and during those 3 days I had maintained the same calm exterior that I always showed to the world, while internally I was calculating timelines and reviewing medical records and trying to understand how Vanessa could possibly believe that announcing a pregnancy would be anything other than a catastrophic exposure of whatever affair she had been conducting behind my back. I had spent years working as a paralegal in a corporate compliance firm where my primary responsibility was reviewing documentation for inconsistencies and timeline violations and evidence of misconduct that companies wanted to identify before regulators or opposing counsel discovered it first, and that professional training had given me an almost instinctive ability to spot contradictions and gaps in narratives that most people would simply accept at face value without questioning the underlying logic. Vanessa had called her parents on Tuesday afternoon and had invited them to come for dinner on Thursday evening, and when I asked her what the occasion was, she had smiled mysteriously and told me that she had some exciting news to share with the family, and that she wanted everyone to be together when she made her announcement. I had known immediately what the news was going to be because there were only so many things that would prompt Vanessa to arrange a formal family dinner with her parents, who lived about 40 minutes away and who typically only came for visits on major holidays or special celebrations like birthdays and graduations. Vanessa's parents arrived at 6:30 in the evening, and they brought a bottle of wine and a bouquet of flowers that Vanessa's mother presented to her with a knowing smile that suggested she had already guessed what the big announcement was going to be, and I watched this exchange from the kitchen doorway while I was setting out plates and silverware on the dining room table that we normally only used for company or for holiday meals. Vanessa's father shook my hand and asked me how things were going at work and whether I had been following the recent Supreme Court decisions about regulatory authority that he had read about in the newspaper, and I provided polite, brief answers while mentally noting that he seemed completely unaware that his daughter was about to reveal information that would fundamentally alter his understanding of his son-in-law's relationship with his daughter. Vanessa had prepared a more elaborate meal than she usually made on weeknights, with roasted chicken and vegetables and a salad and fresh bread from the bakery that she had picked up on her way home from work, and she had set the table with cloth napkins and the good dishes that we kept in the china cabinet and candles that she lit just before we all sat down to eat. Our 3 children were excited by the formal atmosphere and by the presence of their grandparents, and they chattered happily about school and friends and upcoming activities, while Vanessa's mother asked them questions and made encouraging comments about their achievements and their plans. We made it through most of the main course before Vanessa cleared her throat and tapped her wine glass with her fork to get everyone's attention, and the table went quiet as everyone turned to look at her with expectant faces that suggested they were prepared to celebrate whatever happy news she was about to share. Vanessa took a deep breath and smiled broadly and announced that she was pregnant and that we were going to be adding a 4th member to our family sometime in the late summer or early fall, depending on the exact due date that the doctor would confirm at her next appointment. Vanessa's mother let out a small shriek of delight and immediately stood up from her chair and rushed around the table to hug Vanessa and to tell her how wonderful the news was and how exciting it would be to have another grandchild to spoil and to love. And Vanessa's father raised his wine glass in a toast and said something about how blessed we were to have a growing family and how children were the greatest gift that life could offer. Our 3 existing children reacted with a mixture of excitement and confusion because they had not been told that another sibling was coming, and they immediately began asking questions about whether it would be a boy or a girl and where the new baby would sleep and whether they would have to share their toys. I remained seated at my place at the head of the table, and I watched this scene unfold with the same detached analytical perspective that I brought to reviewing evidence in my professional work, and I noticed that Vanessa kept glancing at me as though she was waiting for me to react or to say something that would validate her announcement and confirm that I was as happy about this news as her parents clearly were. I realized that everyone at the table was now looking at me expectantly, waiting for me to express joy or excitement or at least some acknowledgement that this was a momentous occasion that deserved celebration, and I understood that my continued silence was beginning to register as strange or concerning or possibly indicative of some problem that the others could not yet identify. I set down my fork and took a sip of water and told Vanessa and her parents that this was certainly surprising news and that I needed some time to process what I was hearing and to think about what it would mean for our family and our finances and our living arrangements given that our house was already fairly crowded with 3 children and 2 adults. Vanessa's expression shifted from excited anticipation to something more guarded and uncertain, and her mother immediately jumped in to reassure me that the shock of unexpected pregnancy news was completely normal, and that once I had time to adjust to the idea, I would surely be as thrilled as everyone else was about the prospect of welcoming a new baby into our home. Vanessa's father added that 4th children were often the most delightful because parents were more relaxed and experienced by that point, and did not stress about all the small details that made raising the first child so anxiety-producing. And he told a rambling story about his own childhood in a family with 5 siblings and how his youngest brother had been the family favorite because his parents had figured out by that point what really mattered and what was just unnecessary worry. I listened to this story politely and nodded at appropriate moments, but I was actually focused on watching Vanessa's face and trying to determine whether she had convinced herself that I would simply accept this pregnancy announcement without question, or whether she knew that I would eventually discover the impossibility of my being the biological father, and was planning some additional layer of deception to address that problem when it arose. After dessert was served, and the children had been excused from the table to go play in the living room, Vanessa's sister Diane arrived unexpectedly, having apparently been invited by Vanessa to join the celebration, even though she had not been present for the actual announcement at dinner. Diane was 3 years younger than Vanessa and worked as a yoga instructor at a studio in the downtown area, and she had always struck me as being more perceptive and more willing to ask uncomfortable questions than her older sister, who tended to prioritize social harmony and the maintenance of pleasant appearances over confronting difficult truths or acknowledging unpleasant realities. Diane congratulated Vanessa on the pregnancy news and hugged her warmly. But I noticed that when Diane looked at me, her expression became more thoughtful and assessing, as though she was trying to read something in my face or my body language that would help her understand what was really happening beneath the surface of this family celebration. After spending a few minutes chatting with Vanessa's parents about innocuous topics like work schedules and holiday plans, Diane asked me if I could help her carry some items in from her car that she claimed she had brought as gifts for the children, and I recognized this request as a transparent excuse to get me alone for a private conversation, but I agreed anyway because I was curious about what Diane wanted to say to me away from the rest of the family. We walked out to the driveway where Diane's car was parked behind Vanessa's SUV, and as soon as we were out of earshot of the house, Diane turned to me and asked me directly whether I was okay, because she could tell that something about my reaction to the pregnancy announcement had not seemed right. I considered how much I should reveal to Diane at this early stage when I was still gathering information and had not yet decided on my strategy for addressing the situation, and I decided that I would be cautiously honest without providing specific details that might get back to Vanessa before I was ready for a confrontation. I told Diane that I was surprised by the pregnancy announcement because Vanessa and I had agreed, after our 3rd child, that our family was complete and that we were not planning to have any more children, and Diane nodded slowly and said that she had assumed that was the case because Vanessa had mentioned several times over the past couple of years that 3 children were plenty, and that she was looking forward to the stage of life when all the kids were in school and she would have more freedom and flexibility to pursue her own interests and career advancement. I asked Diane whether Vanessa had mentioned anything recently about changing her mind on that question or about wanting to have another baby, and Diane said that no, Vanessa had not said anything like that, and in fact had seemed more focused on her work situation and on some new responsibilities she had been given at the logistics company. I asked Diane if she had noticed anything unusual about Vanessa's behavior or schedule over the past few months, and Diane hesitated for a moment as though she was deciding whether to share something that might be disloyal to her sister or might create problems in our marriage if the information was misinterpreted. After a long pause, Diane told me that she had seen Vanessa at a hotel restaurant about 6 weeks ago having breakfast with a man who was not me, and that while there was nothing obviously inappropriate about the scene, it had struck Diane as odd because Vanessa had not mentioned anything about having breakfast meetings for work, and because the body language between Vanessa and the man had seemed more intimate and familiar than what you would expect from a casual professional acquaintance. I asked Diane to describe the man and to tell me exactly when and where this sighting had occurred. And Diane said that it had been on a Tuesday morning at the Hilton Hotel restaurant that was located near the logistics company where Vanessa worked, and that the man had been wearing business casual clothing with what looked like an employee badge or lanyard around his neck, although Diane had not been close enough to read any identifying information on the badge. Diane said that she had not approached Vanessa during this breakfast because she had been meeting a friend at the hotel spa and had only passed through the restaurant briefly on her way to the spa entrance, and that she had not mentioned the sighting to Vanessa afterward because she did not want to seem like she was spying on her sister or jumping to conclusions about an encounter that might have had a completely innocent explanation. I thanked Diane for sharing this information with me, and I asked her to think carefully about the exact date when she had seen Vanessa at the hotel breakfast, because I wanted to be able to cross-reference that date against other information I was collecting, and Diane said she would check her calendar and her credit card statements from the spa visit to pin down the precise date and would let me know once she had confirmed it. I also asked Diane not to mention this conversation to Vanessa or to anyone else in the family because I needed time to understand what was happening before I decided how to address it, and Diane agreed, but added that she hoped I would be careful and would not do anything rash or destructive that might harm the children or create a situation that could not be repaired if there turned out to be some misunderstanding about what was really going on. We returned to the house carrying some shopping bags that Diane had grabbed from her car to maintain the pretense that we had actually been retrieving items, and we found Vanessa and her parents in the living room, showing the children pictures on Vanessa's phone of what newborn babies looked like and talking about names and nursery decoration ideas. Vanessa looked up when we entered, and her eyes moved quickly between my face and Diane's face as though she was trying to assess whether something significant had been discussed during our absence, and I maintained the same neutral, pleasant expression that I had been wearing all evening while I made some excuse about needing to check my work email and retreated to my home office where I could add Diane's hotel sighting to the growing file of evidence I was building. The morning after the family dinner, I woke up early before Vanessa's alarm had gone off, and I lay in bed staring at the ceiling while going over the information I had accumulated so far and trying to determine what my next step should be in terms of gathering additional evidence before I move forward with any kind of confrontation or legal action. The digital clock on my nightstand showed 5:30 in the morning, and the room was still dark except for the faint glow of streetlights filtering through the bedroom curtains, and I could hear Vanessa's steady breathing beside me and the occasional sounds of our children shifting in their beds in the rooms down the hallway. I carefully extracted myself from under the covers without disturbing Vanessa, and I went downstairs to make coffee and to sit at the kitchen table where I could think through my situation, with the kind of methodical analysis that my professional training had taught me to apply to complex problems that required careful documentation and strategic planning. I knew that Diane would be checking her records to confirm the exact date when she had seen Vanessa having breakfast with the unknown man at the Hilton hotel restaurant, and I also knew that once I had that date, I would be able to cross-reference it against the conception timeline that would be consistent with Vanessa's current stage of pregnancy based on when she was scheduling prenatal appointments. While I was drinking my first cup of coffee and looking out the kitchen window at the gradually brightening sky, I heard the sound of Vanessa's alarm going off upstairs, followed by the familiar morning routine of shower running and closet doors opening and the general commotion of someone getting ready for work in the limited time available before needing to leave the house. I remained at the kitchen table reviewing my mental checklist of evidence and next steps, and I decided that today would be a good day to take a closer look at our shared calendar and our credit card statements to see if there were any patterns or anomalies that would help me understand the scope and duration of whatever deception Vanessa had been engaged in. Vanessa came downstairs approximately 30 minutes later, looking rushed and slightly frazzled, as she always did on weekday mornings when she was trying to coordinate her own preparation, with making sure our oldest child was ready for school and had lunch packed and homework completed, and she poured herself a large travel mug of coffee and grabbed a granola bar from the pantry without sitting down at the table with me. She asked me if I was feeling okay because she had noticed that I seemed distant and preoccupied during dinner the previous evening, and she wanted to make sure I was not upset about the pregnancy news, or feeling overwhelmed by the prospect of having 4 children to support on our current household income. I told Vanessa that I was fine, and that I was simply processing the surprise of the announcement, and thinking through the practical implications of expanding our family when we had already established routines and financial budgets and living arrangements that were based on having 3 children rather than 4. Vanessa nodded and said that she understood my need to think things through methodically because that was how I approached most decisions in life. And she added that she was confident we would figure out how to make everything work once we had time to adjust our plans and our expectations to accommodate the new reality of our growing family. I asked Vanessa if she had told anyone at work yet about the pregnancy and whether she had any concerns about how her employer would react to the news, given that she had only been in her current position at the logistics company for about 18 months and might not have accumulated sufficient leave time to cover an extended maternity absence. Vanessa's expression became slightly guarded, and she said that she had not made any official announcement at work yet, but that she had mentioned it to a few close colleagues who she trusted to be supportive and discreet, and that her supervisor had already indicated informally that the company would work with her to arrange appropriate leave and coverage during whatever time she needed to be away for the birth and initial recovery period. After Vanessa left for work, and after I had helped our oldest child get ready and had driven her to school, I returned home and went directly to my office where I kept my laptop and my personal files separate from the family computer and shared devices that Vanessa had access to. I opened our shared calendar application and began scrolling back through the previous 3 months, looking for any appointments or time blocks that seemed unusual or that did not align with the regular patterns of Vanessa's work schedule and our family commitments and the children's activities. What I noticed as I reviewed the calendar entries was that Vanessa had created a recurring appointment labeled as HR training sessions that appeared on her calendar every other Tuesday afternoon starting about 10 weeks ago, and these appointments were marked as lasting approximately 2 hours each and were scheduled during what should have been normal work hours at the logistics company. I found this pattern suspicious because in my experience, most companies did not conduct HR training sessions with such regular frequency, and because Vanessa had never mentioned attending any ongoing training program that would require her to be away from her normal duties on a bi-weekly basis. I took screenshots of the calendar pages that showed these recurring HR training appointments, and I saved the images to the secure folder on my phone where I was accumulating all of my evidence documentation, and then I logged into our joint credit card account to review the transaction history for the same 3-month period to see if there were any charges that corresponded with the dates of these suspicious calendar appointments. What I discovered when I examined the credit card statements was a pattern of charges from the Hilton hotel that appeared on several of the same dates as the HR training calendar entries. And while the individual charges were relatively small amounts that could have been for coffee or lunch or parking, they created a pattern that suggested Vanessa had been spending time at that hotel location with some regularity over the past several weeks. I used my phone to photograph the relevant sections of the credit card statements that showed the Hilton charges with their dates and amounts clearly visible. And I made note of the fact that these charges had been made on our joint credit card, which meant that Vanessa had either not been concerned about me seeing them or had assumed that I would not pay close enough attention to routine small purchases to notice a pattern. This observation told me something important about Vanessa's assessment of my likely behavior and her belief that she could maintain her deception without significant risk of discovery. And I found myself feeling a cold analytical anger at the calculation that had gone into her decision to use our shared financial resources to facilitate whatever relationship she was conducting with the man Diane had seen her with at the hotel restaurant. I spent the next hour creating a detailed timeline document that organized all of the information I had gathered so far into a chronological sequence that would make it easy to see the connections and patterns that were emerging from the evidence. I started the timeline with the date of my vasectomy procedure 2 years ago and included the follow-up confirmation of successful sterilization, and then I added the approximate conception window that would be consistent with Vanessa's current pregnancy based on the prenatal appointment she had scheduled and the typical dating methods that doctors used in early pregnancy. I marked the dates when the HR training calendar appointments had appeared on our shared schedule, and I noted the corresponding Hilton credit card charges, and I added the approximate date of Diane's hotel restaurant sighting, which I was still waiting for her to confirm precisely. When I laid out all of this information in a single document, the picture that emerged was one of systematic deception that had been planned and executed with enough care to avoid obvious detection, but not with sufficient attention to the kind of detailed evidence review that someone with my professional background would naturally conduct once suspicion had been raised. I realized that Vanessa had probably assumed that I was too busy with my work and too focused on my daily routines to notice small anomalies in our calendar or minor charges on our credit card statement, and that assumption had led her to become careless in ways that were now providing me with exactly the kind of documented proof I would need if the situation eventually required legal intervention or formal proceedings of any kind. Around mid-morning, I received a text message from Diane saying that she had checked her records and had confirmed that the date when she had seen Vanessa at the Hilton Hotel restaurant was exactly 8 weeks ago on a Tuesday morning, and she included a screenshot of her own credit card statement showing a charge from the hotel spa on that date as verification that her memory was accurate. I thanked Diane for the confirmation, and I added this information to my timeline document, and I noted that 8 weeks ago fell almost exactly in the middle of the conception window that would be consistent with Vanessa's current pregnancy status, and that it also corresponded with one of the recurring Tuesday appointments that Vanessa had labeled as HR training sessions on our shared calendar. I sat back in my office chair and looked at the timeline document I had created, and I felt the same sense of clarity and certainty that I experienced in my professional work, when a complex compliance investigation suddenly crystallized into a clear pattern of misconduct that could be documented and proven through objective evidence rather than through subjective testimony or disputed interpretations of ambiguous circumstances. I knew that I now had sufficient information to confront Vanessa directly if I chose to do so, but I also knew from my professional experience that premature confrontation often gave the target of an investigation time to destroy evidence or to construct counter-narratives or to take defensive actions that could complicate the eventual resolution of the situation. I decided that before I took any action, I needed to consult with an attorney who could advise me on the legal implications of what I had discovered and who could help me understand what rights I had and what procedures I should follow to protect my interests and the interests of my children, who were going to be affected by whatever happened next in my marriage. I looked through my professional contacts and found the phone number for Marshall Kent, who was a family law attorney I had worked with on several employment cases that had involved custody disputes and separation agreements, and I called his office and explained to his assistant that I needed to schedule a confidential consultation regarding a potential separation matter that involved questions about paternity and financial obligations. Marshall's assistant checked the calendar and told me that Marshall had an opening the following afternoon at 3 o'clock if I could come to his office downtown, and I confirmed the appointment and made a note to block out that time on my own work calendar with a vague label about client meetings that would not attract attention from anyone who might be reviewing my schedule. After I hung up the phone, I sat for a few minutes thinking about how quickly my life had shifted from what I had believed was a stable, predictable routine into a situation that was going to require legal representation and formal proceedings, and decisions about custody arrangements and property division, and all of the other messy, complicated consequences that came with the dissolution of a marriage. That evening, when Vanessa came home from work, she seemed more relaxed and cheerful than she had been in the morning, and she told me that she had officially informed her supervisor about the pregnancy and that the conversation had gone well, and that her supervisor had been supportive and had immediately begun discussing options for maternity leave coverage and flexible scheduling that would make it easier for Vanessa to manage prenatal appointments and eventual childcare responsibilities. I listened to Vanessa describe this conversation, and I noted the irony that she was making detailed plans for maternity leave and childcare based on a pregnancy that she must have known I could not possibly have been responsible for, and I wondered what explanation she was planning to offer when the question of paternity eventually arose in a context where medical records and DNA testing would make the truth undeniable. I asked Vanessa if she had given any thought to how we were going to manage the financial impact of having another child, given that our current budget was already stretched fairly thin with 3 children and the various expenses associated with their school activities and healthcare, and the general cost of raising kids in a suburban area where housing and living expenses were not insignificant. Vanessa responded by saying that she had been thinking about this question and that she believed we could manage by cutting back on some discretionary spending and by being more strategic about how we allocated our resources. And she also mentioned that there might be opportunities for her to take on additional responsibilities at work that would come with modest pay increases that could help offset some of the new expenses. I noticed as Vanessa was talking about her work situation that she mentioned several times her interactions with someone she referred to only as her mentor, who had been giving her advice about career advancement and professional development opportunities. And while she did not provide any specific identifying information about this mentor, I made a mental note of the repeated references because it seemed possible that this might be the same person who Diane had seen having breakfast with Vanessa at the hotel restaurant 8 weeks ago. I did not ask Vanessa any direct questions about her mentor because I did not want to alert her to my suspicions, but I filed away this information as another data point that might become relevant as I continued to gather evidence and build my understanding of the full scope of her deception. The following afternoon, I left my office at 2:30 and drove downtown to the building where Marshall Kent maintained his family law practice in a suite on the 14th floor that had views of the courthouse district and the government buildings that housed the various administrative offices responsible for processing divorce filings and custody arrangements, and all of the other legal machinery that managed the formal dissolution of marriages. I had dressed in my usual work attire of dress pants and a button-down shirt and a sport coat that would allow me to blend in with the other professionals who populated this part of the city during business hours, and I carried a leather portfolio that contained printed copies of all the evidence I had assembled, including the screenshots of calendar appointments and credit card charges and the photograph of my vasectomy confirmation letter. Marshall's office was decorated in the kind of understated professional style that was meant to convey competence and discretion rather than flashy success, with dark wood furniture and framed diplomas and bar certifications on the walls and shelves lined with legal reference books that probably went mostly unused in an era when most legal research was conducted through online databases. Marshall himself was in his late 40s with graying hair and the slightly weary expression of someone who had spent decades listening to the intimate details of failing marriages and contentious custody battles. And when his assistant showed me into his private office, he stood up from behind his desk and shook my hand and gestured for me to take a seat in one of the leather chairs, positioned across from where he sat. Marshall began the consultation by explaining that everything we discussed would be protected by attorney-client privilege and that I should feel free to share all relevant information, even if some of it seemed embarrassing or reflected poorly on my own behavior, because he needed to have a complete and accurate understanding of the situation in order to provide useful advice about my legal options and the likely outcomes of various courses of action I might choose to pursue. I appreciated Marshall's direct approach and his acknowledgement that most people who came to see family law attorneys were dealing with situations that involved some degree of personal failure or poor judgment. And I told him that in my case, I believed the facts would show that I had been the victim of deliberate deception rather than a contributor to the breakdown of my marriage. I started my explanation by telling Marshall about the prenatal clinic appointment notification I had seen on our shared tablet and about my immediate recognition that this pregnancy could not possibly be mine because I had undergone a vasectomy procedure approximately 2 years ago that had been confirmed as successful through follow-up medical testing. Marshall listened without interrupting and made occasional notes on a legal pad in front of him, and when I finished describing the basic facts of my discovery, he asked me whether I had the documentation to prove the vasectomy and whether I had confronted my wife about the pregnancy or had taken any steps that might have alerted her to my suspicions. I opened my portfolio and handed Marshall a printed photograph of my vasectomy confirmation letter showing the date of the procedure and the verification of successful sterilization, and I explained that I had not confronted Vanessa directly because I wanted to gather complete information about the scope of her deception before I made any decisions about how to proceed. Marshall examined the vasectomy documentation carefully and then looked up at me and said that this was exactly the kind of clear objective evidence that would be crucial if we needed to challenge paternity claims or contest financial obligations related to a child that was not biologically mine, and that my instinct to document everything before confronting my wife had been correct because once people knew they were under scrutiny, they often took steps to hide evidence or construct alternative explanations that could complicate legal proceedings. I then walked Marshall through the rest of the evidence I had compiled, including the timeline of recurring HR training appointments on our shared calendar that did not correspond to any actual training program at Vanessa's workplace, the pattern of credit card charges from the Hilton hotel that appeared on the same dates as those calendar appointments, and the witness statement from Vanessa's sister, Diane, who had seen Vanessa having breakfast at the Hilton with an unidentified man approximately 8 weeks ago during the time frame that would align with the conception window for the current pregnancy. Marshall reviewed each piece of evidence methodically and asked detailed questions about how I had obtained the information and whether there were any gaps or inconsistencies in the documentation that might create problems if we needed to present this evidence in court or in settlement negotiations. Marshall explained that in our state paternity was typically established through a legal presumption that any child born to a married woman was the biological child of her husband unless evidence was presented to rebut that presumption, and that my vasectomy documentation would be sufficient to overcome the presumption and to require that paternity testing be conducted before any child support or custody obligations could be assigned to me. He also explained that if DNA testing confirmed that I was not the biological father of Vanessa's child, then I would have no legal obligation to provide financial support for that child, and that the courts would require Vanessa to identify the actual biological father, who would then become responsible for child support payments. I asked Marshall whether Vanessa's use of our joint credit card to pay for hotel charges that were connected to her affair could be relevant in any separation or divorce proceedings, and Marshall said that while infidelity itself was not technically grounds for fault-based divorce in our state, the misuse of marital funds to facilitate an extramarital affair could be considered in the division of property and in determinations about spousal support. He explained that if I could document a pattern of Vanessa spending our shared money on her relationship with another man, then I could argue that she had misappropriated marital assets, and that this should be factored into the financial settlement in ways that would reduce any spousal support obligations I might otherwise have had. Marshall asked me what outcome I was hoping to achieve through legal action, and whether my primary goal was to end the marriage, or to establish paternity of the child, or to protect my financial interests, or some combination of those objectives, and I told him that my immediate priority was to ensure that I was not legally or financially responsible for a child that was not biologically mine, and that I wanted to establish a clear factual record that would document Vanessa's deception so that it could not be rewritten or reinterpreted in ways that might make me appear to be the villain in this situation. I also told Marshall that I had 3 children with Vanessa who I cared about deeply and who I wanted to protect from unnecessary harm or trauma, and that whatever legal strategy we pursued needed to take into account the well-being of those children who were going to be affected by the dissolution of their parents' marriage, regardless of how carefully we tried to manage the process. Marshall nodded and said that protecting the interests of existing children was always a complicated aspect of divorce cases involving infidelity and disputed paternity, and that the courts would generally try to maintain stability and continuity for children who had established relationships with both parents, even when one parent had engaged in behavior that had damaged the marriage. He explained that custody arrangements would likely be based on assessments of what would serve the best interests of the children, rather than on any attempt to punish Vanessa for her affair, and that I should be prepared for the possibility that even if I could prove Vanessa's infidelity, that might not result in me being awarded sole custody or significantly more parenting time than I would have received in a standard separation agreement. I asked Marshall what he thought my next steps should be given the evidence I had already compiled, and given my goal of establishing a clear record before Vanessa had an opportunity to construct a defensive narrative, and Marshall said that he would recommend filing for legal separation immediately based on the irreconcilable differences that had been created by Vanessa's pregnancy with another man's child. He explained that by filing first, I would have some control over the timing and framing of the legal proceedings, and that the separation filing would create an official record that would include my statement that I was not the biological father of Vanessa's unborn child, and that would require her to respond to that claim with evidence of her own. Marshall also suggested that I should consider gathering additional information about the identity of Vanessa's affair partner if possible, because knowing who that person was might be strategically useful in several ways, including potential claims against that person, for alienation of affection in states where such claims were still recognized, or for purposes of establishing child support obligations once paternity was confirmed. I told Marshall that I suspected from Vanessa's recent comments about a workplace mentor and from Diane's observation about the man wearing what appeared to be an employee badge that the affair partner was likely someone who worked at the same logistics company where Vanessa was employed, and Marshall said that if that was the case, then there might also be potential employment-related complaints or ethics violations that could create additional pressure on both Vanessa and her affair partner. Marshall explained that many companies had policies prohibiting romantic relationships between employees, particularly when one person had supervisory authority over the other, and that if Vanessa's affair partner was in a position of workplace authority, then there might be grounds for filing a complaint with the company's Human Resources Department or Ethics Office that could result in professional consequences for that person, separate from any legal proceedings related to the divorce or paternity issues. I found this suggestion interesting because it aligned with my own instinct that the most effective strategy for dealing with misconduct was often to create multiple simultaneous consequences through different channels, rather than relying on any single legal proceeding or confrontation to achieve accountability. Before I left Marshall's office, we discussed the practical timeline for moving forward with a separation filing and the likely sequence of events that would follow once the paperwork was submitted to the court, and Marshall explained that after I filed for separation, Vanessa would be served with notice of the filing and would have a specified period of time to respond with her own claims and defenses. He said that at some point during this process, the court would likely order paternity testing to resolve the question of whether I was the biological father of Vanessa's unborn child, and that once those test results came back showing that I was not the father, then the court would require Vanessa to identify the actual biological father so that appropriate child support and custody arrangements could be established. Marshall also warned me that I should expect Vanessa to be angry and defensive when she received notice of the separation filing and that she might make accusations about my behavior or my fitness as a parent in an attempt to shift blame or to create a more favorable negotiating position for herself. He advised me to avoid any direct confrontations with Vanessa outside of formal legal proceedings and to document all of my interactions with her through email or text messages so that there would be a clear record of what was said and what actions were taken by each party as the separation process unfolded. I thanked Marshall for his time and his advice, and I authorized him to begin preparing the separation filing paperwork that would include my statement about the disputed paternity of Vanessa's pregnancy, and that would formally initiate the legal process that would eventually result in the dissolution of my marriage. As I rode the elevator back down to the ground floor and walked through the downtown streets toward the parking garage where I had left my car, I felt a strange mixture of relief that I had taken concrete action to protect my interests and sadness about the ending of a relationship that had once felt stable and promising, even if it had ultimately been revealed as built on foundations that were much less solid than I had believed. That evening, when I returned home, Vanessa was already there, preparing dinner and helping our children with their homework, as she did on most weekday evenings. And I observed her going through these familiar routines, and I found myself wondering what she was thinking about, and whether she had any awareness that her deception was about to be exposed through a legal filing that would create a permanent public record of her infidelity and the disputed paternity of the child she was carrying. Over the next several days, I maintained my usual routines and responsibilities, while Marshall worked on preparing the separation paperwork that would formally initiate legal proceedings, and would require Vanessa to respond to my claims about disputed paternity and about the affair that I had documented through calendar entries and credit card statements and witness observations. I went to work each morning and attended meetings and reviewed compliance documents and responded to client requests with the same professional focus I had always maintained, and I came home each evening and helped with dinner preparation and homework supervision and bedtime routines with our 3 children who remained blissfully unaware that their parents' marriage was about to undergo a fundamental transformation that would affect every aspect of their daily lives. Vanessa seemed to be operating under the assumption that my initial surprised reaction to her pregnancy announcement had given way to acceptance and adjustment, and she had begun making plans for how we would rearrange our living space to accommodate a 4th child, and how we would manage the logistics of additional daycare expenses and pediatrician appointments and all of the practical details that came with expanding a family. She had purchased several baby name books and had left them on the coffee table in our living room, where she would occasionally flip through them while watching television in the evenings, and she had started browsing online retailers for infant clothing and nursery furniture, as though she was preparing for a normal anticipated addition to our household, rather than for the exposure of an affair that would destroy the family structure she was pretending to maintain. I found Vanessa's behavior during this period to be both fascinating and disturbing from a psychological perspective, because it suggested either that she had genuinely convinced herself that I would never discover or question the biological impossibility of her pregnancy, or that she was engaged in some kind of elaborate denial mechanism that allowed her to compartmentalize the reality of her situation in ways that prevented her from confronting the inevitable consequences of her deception. I had seen similar patterns in my professional work when reviewing cases of corporate fraud where executives had continued to generate false financial reports and to make public statements about company performance even when they must have known that auditors and regulators would eventually uncover the truth, and I had always been struck by the human capacity for self-deception and for believing that somehow circumstances would work out favorably despite overwhelming evidence to the contrary. On the 4th day after my consultation with Marshall, I received an email from him indicating that the separation paperwork had been completed and was ready for my review and signature, and he attached PDF copies of the documents so that I could examine them before coming to his office to sign the final versions that would be filed with the court. I waited until I was alone in my home office that evening after Vanessa and the children had gone to bed, and then I opened the attachments and read through each page carefully to verify that all of the information I had provided had been accurately reflected in the legal language that Marshall had used to construct my claims and my requests for relief from the court. The petition for legal separation that Marshall had prepared stated clearly that I was seeking separation based on irreconcilable differences that had arisen due to my wife's pregnancy with a child that could not biologically be mine given my documented vasectomy and successful sterilization, and it included a request that the court order paternity testing once the child was born to definitively establish that I was not the biological father and therefore had no legal or financial obligations toward that child. The petition also included detailed information about our 3 existing children and a request that custody arrangements for those children be determined based on their best interests and on assessments of each parent's ability to provide stable, appropriate care. And it noted that I was willing to maintain joint custody arrangements and to continue meeting my financial obligations toward my biological children, regardless of the circumstances surrounding the separation from my wife. Marshall had also included in the separation petition a section documenting the misuse of marital funds that I had identified through my review of our joint credit card statements, and he had attached copies of the credit card bills showing the pattern of Hilton hotel charges that corresponded with calendar appointments that Vanessa had falsely labeled as work-related training sessions. The petition explained that these charges represented an inappropriate diversion of marital assets to facilitate an extramarital affair, and that this misappropriation should be considered in any determination of property division and spousal support obligations, and it requested that the court take into account this misconduct when deciding what financial arrangements would be fair and appropriate given the circumstances that had led to the breakdown of the marriage. I reviewed the separation petition multiple times to ensure that I was comfortable with every statement and every request for relief that Marshall had included, and I made a few minor suggestions for clarifying language in certain sections where I thought the wording could be more precise or could better reflect the specific facts of my situation. After I had completed my review, I sent an email back to Marshall indicating that I was satisfied with the documents and asking when I should come to his office to sign the final versions that would be submitted to the court. And Marshall responded the next morning saying that I could come by any time that afternoon and that once I had signed the paperwork, he would file it electronically that same day so that the legal process would be officially initiated. I left work early that afternoon, telling my supervisor that I had a personal appointment that I needed to attend to, and I drove to Marshall's office, where I spent approximately 30 minutes reviewing the final printed versions of all the separation documents and signing each page in the places that Marshall had marked with small adhesive tabs. Marshall explained that once he filed the petition electronically, the court would assign a case number and would generate a summons that would need to be formally served on Vanessa, and that he would arrange for a professional process server to deliver the summons and a copy of the separation petition to Vanessa either at our home or at her workplace, depending on which location seemed most appropriate for ensuring that she received the documents without creating an unnecessary public scene. I told Marshall that I thought it would be better to have Vanessa served at our home rather than at her workplace, because I did not want to create embarrassment for her in front of her colleagues before she had a chance to understand the full situation and to consult with her own attorney about how to respond. Marshall agreed that home service was usually preferable in cases like mine, where there was not a concern about the respondent evading service or refusing to accept documents, and he said that he would instruct the process server to attempt delivery on an evening when Vanessa was likely to be home, but when I could arrange to be somewhere else so that I would not be present during what would inevitably be a difficult and emotional moment when she realized that I had filed for separation. After I left Marshall's office, I sat in my car in the parking garage for several minutes thinking about the fact that I had just set in motion a legal process that would fundamentally alter the trajectory of my life and the lives of my children, and would expose publicly the private betrayal that Vanessa had been conducting behind the facade of our supposedly stable marriage. I felt no particular satisfaction or triumph in having taken this action, because my primary emotion was not anger or desire for revenge, but rather a kind of cold disappointment that the life I had thought I was building had turned out to be based on deceptions that I had been too trusting or too inattentive to notice until circumstances had made them impossible to ignore. I drove from the parking garage to a coffee shop where I sat with my laptop and began drafting a careful email to Vanessa's sister, Diane, informing her that I had filed for separation, and explaining that I wanted her to know this information directly from me rather than hearing about it secondhand from Vanessa or from other family members who would inevitably become involved once the legal proceedings became public knowledge. I thanked Diane for having shared with me her observation about seeing Vanessa at the hotel restaurant, and I told her that her willingness to be honest about what she had witnessed had been an important factor in helping me understand the full scope of what was happening in my marriage. And I said that I hoped she would not feel caught in the middle of a family conflict that I recognized would be difficult and painful for everyone involved. Diane responded to my email within an hour with a message saying that she had suspected after our conversation in the driveway that I was dealing with something more serious than just surprise about an unexpected pregnancy announcement, and that while she was sad about the breakdown of my marriage to her sister, she respected my decision to take action based on evidence rather than simply accepting a situation that clearly did not make sense given the medical facts I had shared with her. Diane also said that she was willing to provide a written statement about what she had observed if that became necessary for legal proceedings, but that she hoped Vanessa would be reasonable and honest in her own response to the separation filing, so that the process could move forward without requiring extended litigation or contentious disputes about facts that were ultimately not seriously in question. That evening, when I arrived home, Vanessa was in the kitchen preparing dinner, and she greeted me with her usual casual warmth, asking about my day at work and telling me about a conversation she had with her supervisor about potential maternity leave scheduling that would allow her to take several months off after the baby was born while still maintaining her position and her benefits with the logistics company. I listened to Vanessa describe these plans, and I provided minimal responses, while mentally noting that within the next few days she would be receiving legal documents that would make clear that I had no intention of supporting her through a maternity leave for a child that was not biologically mine, and that her employment arrangements and benefits would need to be negotiated without any assumption of financial contribution or shared responsibility from me. After dinner, I told Vanessa that I needed to spend the evening working on some case files that had urgent deadlines, and I retreated to my home office where I could monitor my email for updates from Marshall about when the process server would attempt to deliver the separation documents to Vanessa. Marshall sent me a message around 8 o'clock that evening, indicating that the process server had agreed to attempt service the following evening around 6:30, when most people would typically be home from work, and that I should plan to be away from the house during that time window so that I would not be present when Vanessa received the documents and had her initial reaction to discovering that I had filed for separation. The next day, I went through my work routine with the knowledge that by the end of the evening, my marriage would have moved from private dysfunction into formal legal proceedings that would require Vanessa to respond publicly to claims about her infidelity and about the disputed paternity of the child she was carrying. I felt a strange sense of anticipation mixed with dread because I knew that once Vanessa was served with the separation documents, there would be no going back and no possibility of pretending that our marriage was anything other than fundamentally broken by deceptions that could not be reconciled or explained away through conversations or counseling or any of the typical interventions that couples might attempt when facing less severe relationship problems. I left work at my normal time and drove home where I found Vanessa already preparing dinner, as she usually did on weekday evenings, and I told her that I had received a last-minute request from a colleague to meet for drinks to discuss a work matter and that I would probably not be home until later in the evening. Vanessa seemed unconcerned by this explanation and told me that she would save a plate of food for me that I could reheat when I returned, and I left the house at approximately 6:15, knowing that the process server would likely arrive within the next 30 to 45 minutes to deliver the documents that would shatter whatever sense of normalcy Vanessa had been maintaining. I drove to a park several miles from our house, and I sat on a bench near a playground where parents were supervising their children on swings and slides and climbing structures, and I watched these ordinary scenes of family life while checking my phone repeatedly for any message from Marshall or from the process server confirming that the documents had been successfully delivered to Vanessa. The process server sent me a text message at 7:15 confirming that he had successfully delivered the separation petition and summons to Vanessa at our home address, and that she had accepted the documents after initially appearing confused about what they were and who was delivering them. The process server's message included a brief description of Vanessa's reaction, which he characterized as shocked and disbelieving when she had opened the envelope and had seen the first page of the legal filing with the case caption that listed me as the petitioner and her as the respondent in a matter of legal separation. And he noted that she had asked him several questions about whether this was some kind of mistake, or whether the documents were legitimate court filings that required her to take action. I sat on the park bench for another 30 minutes after receiving the process server's confirmation message because I wanted to give Vanessa some time to read through the separation petition and to process the information it contained before I returned home to face whatever confrontation or conversation would inevitably follow once she had absorbed the reality that I knew about her pregnancy's biological impossibility and about the affair that she had been conducting while pretending to maintain a normal marriage. I watched the families at the playground gradually disperse as the evening light faded and parents began collecting their children and loading them into cars to return home for bedtime routines, and I thought about how my own children's lives were about to become significantly more complicated and disrupted by the separation that was now officially underway. When I finally drove back to our house at approximately 8 o'clock, I found Vanessa sitting alone at the kitchen table with the separation documents spread out in front of her, and with her phone beside her showing what appeared to be a paused call or a text message conversation that she had been engaged in while reading through the legal papers. She looked up when I entered through the side door from the garage, and her expression was a mixture of anger and confusion and something that might have been genuine hurt or might have been a calculated display of wounded innocence meant to make me feel guilty for having taken legal action, without first giving her an opportunity to explain or defend herself. Vanessa asked me in a voice that was trying to sound calm but had an underlying edge of barely controlled rage whether I was seriously claiming in legal documents filed with the court that I believed she had been having an affair and that the baby she was carrying was not mine, and she demanded to know what possible evidence I could have for making such accusations when she had never given me any reason to doubt her faithfulness or her commitment to our marriage. I remained standing near the doorway rather than sitting down at the table because I wanted to maintain some physical distance during this conversation, and because I had learned from observing difficult confrontations in my professional work that staying on your feet gave you more options for managing the interaction and more ability to leave if the situation became too heated or unproductive. I told Vanessa that the evidence for my claims was documented in the separation petition that she had just received, and that included the vasectomy confirmation letter showing that I had been medically sterilized 2 years ago and could not possibly have fathered the child she was currently carrying. And I said that beyond that fundamental biological impossibility, I had also compiled evidence of her recurring appointments at the Hilton Hotel that corresponded with calendar entries she had falsely labeled as work training sessions, and that there was a witness who had observed her having breakfast at that hotel with a man who was not her husband. Vanessa's face went pale as I described this evidence, and I could see her mind working through possible responses or explanations that might allow her to maintain some version of her story. But she seemed to realize that the documentation I had assembled left very little room for alternative narratives that would be credible or convincing. Vanessa shifted her approach from defensive denial to tearful confession, and she admitted that, yes, she had been seeing someone from her workplace, and that the relationship had started several months ago during a period when she had been feeling undervalued and unappreciated in our marriage and had found herself drawn to someone who seemed to understand her professional ambitions and her desire for recognition in ways that she felt I had never really grasped or supported. She said that the affair had not been planned or intentional, but had developed gradually from a mentoring relationship into something more personal, and ultimately into a sexual involvement that she knew was wrong, but that she had convinced herself was filling an emotional need that was not being met within our marriage. I listened to Vanessa's explanation without interrupting because I wanted to hear what story she would construct and what details she would include or omit in her version of events, and I noted that she was framing the affair as something that had happened to her, rather than as a series of deliberate choices she had made to deceive me and to use our shared financial resources to facilitate a relationship with another man. She did not mention the man's name during her initial confession, and I decided not to ask for that information at this point because I was more interested in seeing whether she would volunteer it or whether she would try to protect his identity in hopes of minimizing the consequences he might face for his role in the affair. I asked Vanessa whether she had told this other man that she was pregnant with his child, and whether he was aware that she had been planning to pass the child off as mine, and to use the pregnancy to secure financial support and custody advantages in whatever separation or divorce proceedings might eventually occur. Vanessa hesitated, and then admitted that yes, she had told him about the pregnancy and that he had initially been supportive, but had recently become distant and worried about the professional consequences he might face if the affair became public knowledge, particularly given that he held a supervisory position at the logistics company and had some authority over employment decisions that affected Vanessa and other workers in her department. This confirmation that Vanessa's affair partner was someone in a position of workplace authority gave me the information I needed to potentially file an ethics complaint or a human resources grievance that could create professional consequences for him, separate from whatever legal proceedings would unfold regarding the separation and the disputed paternity. And I made a mental note to discuss this option with Marshall at our next meeting. I told Vanessa that I expected her to identify the biological father of her child in her response to the separation petition, because the court would require that information in order to establish appropriate child support obligations and custody arrangements, and Vanessa immediately became agitated and said that she did not want to name him publicly because it would ruin his career and would destroy his own marriage and family. I found it grimly amusing that Vanessa was expressing concern about protecting her affair partner's career and marriage when she had shown no similar concern about the impact her deception might have had on our own marriage or on our children's stability and well-being, and I pointed out that her desire to shield him from consequences was not something that the court would accommodate because the legal system required accurate identification of biological parents in order to ensure that children received appropriate financial support from the people who were actually responsible for their existence. Vanessa began crying and saying that she had never intended for any of this to happen and that she had thought she could manage the situation in ways that would not cause harm to anyone, and I realized that she genuinely seemed to have convinced herself that somehow she could maintain both her affair and her marriage without anyone discovering the truth or suffering any negative consequences. I told Vanessa that we would need to establish some immediate practical arrangements regarding our living situation and our interactions with the children during the separation process, and I said that I thought it would be best if she moved out of the house temporarily so that the children could maintain their routines in familiar surroundings while we worked through the legal proceedings and figured out what longer-term custody and living arrangements would look like. Vanessa objected strongly to this suggestion and said that she should not be the one forced to leave when this was the family home that she had helped to create and maintain, but I pointed out that I was the one who had filed for separation based on her misconduct and that it would be much more disruptive for the children if I moved out and changed their daily patterns of school drop-offs and pickups and evening routines. The conversation continued for another hour with Vanessa alternating between tearful apologies and angry accusations about my lack of emotional availability and my failure to appreciate the pressures she had been under at work and in managing our household and our children's activities, and I maintained a calm, analytical posture throughout, because I had learned from my professional experience that allowing confrontations to become emotionally charged rarely produced useful outcomes, and usually just created additional conflicts that made resolution more difficult. Eventually, Vanessa seemed to exhaust herself, and she asked me what I expected her to do next in terms of responding to the separation petition, and I told her that she should hire her own attorney who could advise her about her legal options and her obligations, and who could help her prepare a response that would be filed with the court within the time frame specified in the summons she had received. Over the next several days, Vanessa and I maintained a cold but functional coexistence in our house while she consulted with a family law attorney who she had found through a referral from one of her coworkers, and while we both tried to maintain normal routines with our 3 children who were beginning to sense that something was wrong between their parents, even though we had not yet told them directly about the separation or about the changes that would be coming to their living arrangements. I continued going to work and attending to my professional responsibilities while also communicating regularly with Marshall about developments in the case and about strategy for the next phases of the legal proceedings. And Marshall informed me that Vanessa's attorney had contacted him to request an extension of time for filing her response to the separation petition and to explore whether there might be possibilities for reaching a settlement agreement without extended litigation. Marshall advised me that settlement discussions at this early stage were unlikely to be productive because the fundamental facts of the case regarding my vasectomy and the biological impossibility of the pregnancy were not matters that could be negotiated or compromised, and that we would need to wait until after paternity testing was completed before we could have meaningful conversations about what financial and custody arrangements would be appropriate. I agreed with Marshall's assessment and told him that I was not interested in negotiating any settlement that would require me to take legal or financial responsibility for a child that was not biologically mine, and that my priority was protecting my rights and obligations regarding my 3 existing children while ensuring that Vanessa's affair partner was held accountable for his role in creating this situation. Marshall asked me whether I had been able to determine the identity of Vanessa's affair partner and whether I wanted to pursue any kind of formal complaint against him, either through his employer or through other channels that might create consequences for his behavior, and I told Marshall that Vanessa had confirmed the affair partner worked at her company in a supervisory role, but that she had refused to name him directly in our conversations. Marshall suggested that we could include in our discovery requests a demand that Vanessa identify the biological father of her unborn child, and that we could also subpoena employment records from the logistics company if we needed to establish the nature of the relationship and whether it had involved any abuse of workplace authority or violations of company ethics policies. I found the idea of subpoenaing employment records appealing because it would create a formal, documented investigation that would be difficult for either Vanessa or her affair partner to conceal or minimize, and I told Marshall that I wanted to pursue that option as aggressively as the legal procedures would allow. Marshall explained that he would need to wait until Vanessa filed her response to the separation petition before he could begin formal discovery requests, but that once that response was filed, he would immediately serve document requests and interrogatories that would require Vanessa to provide detailed information about her affair, including the identity of her partner and the timeline of their relationship and the circumstances under which they had met and conducted their encounters. During this waiting period, while we anticipated Vanessa's formal response to the separation petition, I received an unexpected phone call one evening from a woman who identified herself as Nina Vance and who explained that she was calling because she had seen my name on the public court docket as having filed a separation case, and she believed that her husband might be the person who had been having an affair with my wife. Nina Vance explained during that initial phone call that she worked as a nurse at the county hospital and that she had been reviewing public court records online as part of her own investigation into her husband's suspicious behavior over the past several months, and that when she had seen the filing in my separation case with references to disputed paternity and to an affair involving someone from a logistics company, she had immediately recognized that the details aligned with information she had discovered through her own examination of credit card statements and work schedules that had raised questions about where her husband had been spending his time. Nina said that her husband, Jordan Vance, was the human resources manager at the same logistics company where my wife, Vanessa, worked, and that she had found hotel charges and unexplained absences and text message fragments that suggested he had been involved in an extramarital relationship that he had been trying to conceal through a combination of deleted communications and fabricated work obligations. I listened carefully to Nina's description of what she had discovered, and I felt a cold clarity settling over me as I realized that this phone call was providing me with the final piece of information I needed to establish. Not just the identity of Vanessa's affair partner, but also the workplace power dynamic that had been part of their relationship, and that would be relevant for both legal proceedings and potential employment ethics complaints. I asked Nina how she had determined that her husband's affair was specifically with my wife rather than with some other employee at the logistics company, and Nina explained that she had found a credit card receipt from a restaurant charge that included a handwritten note with the name Vanessa and a phone number that Nina had called from a blocked number to verify that it belonged to my wife. Nina told me that she had been debating for several weeks whether to confront her husband directly about the affair or whether to gather more evidence before taking any action, and that seeing my court filing had helped her understand that there was another family being affected by the same deception, and that perhaps we could coordinate our efforts to ensure that both Jordan and Vanessa faced appropriate consequences for their behavior. I appreciated Nina's direct approach and her recognition that we had aligned interests in documenting the affair and in holding both participants accountable, and I suggested that we should meet in person to compare the evidence we had each assembled and to discuss how we might coordinate our legal strategies and any employment complaints we might want to file. We arranged to meet 2 days later at a coffee shop that was located in a part of town that was not near either of our homes or workplaces, so that we could have a private conversation without risk of being observed by anyone who might recognize us and might report back to either Vanessa or Jordan. When I arrived at the coffee shop, Nina was already seated at a corner table with a folder of documents in front of her, and when I sat down across from her, I could see immediately that she had the same methodical evidence-gathering approach that I had used in my own investigation, with organized timelines and highlighted credit card statements and printed text message screenshots that showed suspicious patterns even where the actual content of messages had been deleted. Nina showed me the hotel receipts she had found in Jordan's credit card records that matched the dates of the Hilton charges that had appeared on my own credit card statement, and we compared the dates and times and confirmed that there were at least 6 occasions over the past 3 months when both Vanessa and Jordan had charges from the same hotel on the same date, which created a clear pattern of coordinated meetings that could not reasonably be explained as coincidental. Nina also showed me a copy of Jordan's work calendar that she had managed to photograph from his phone during a moment when he had left the device unattended, and that calendar showed recurring block time periods labeled as confidential HR meetings that corresponded exactly with the fake training sessions that had appeared on Vanessa's shared calendar with me. I shared with Nina the evidence I had compiled, including my vasectomy documentation and the witness statement from Vanessa's sister Diane, who had seen Vanessa and an unidentified man having breakfast at the hotel restaurant, and Nina confirmed that the time frame of that sighting aligned perfectly with Jordan's calendar entries and with a particular credit card charge that showed breakfast purchased at the hotel restaurant on that same morning. We spent approximately an hour reviewing all of our combined evidence and creating a master timeline that showed the progression of the affair from its apparent beginning about 4 months ago, through the present situation where Vanessa was pregnant and I had filed for separation and Nina was preparing to take her own legal action against Jordan. Nina told me that she planned to file for divorce from Jordan and that she wanted to include in her filing specific allegations about his abuse of his workplace authority to conduct an affair with a subordinate employee, which would be relevant both for the divorce proceedings and for any employment ethics complaints that might be filed with the logistics company. I explained to Nina that I was also planning to file an ethics complaint with the company once I had confirmed Jordan's identity as Vanessa's affair partner, and that my attorney, Marshall Kent, had advised me that such complaints could create professional consequences that would be separate from but complementary to the legal proceedings related to separation and child support obligations. Nina asked me whether I knew if Jordan was aware that Vanessa was pregnant with his child, or whether Vanessa had been keeping that information from him. And I told Nina that Vanessa had mentioned during our confrontation after she received the separation documents that Jordan initially knew about the pregnancy but had recently become distant and worried about professional consequences. Nina said that this timing made sense because she had noticed that Jordan had become increasingly anxious and distracted over the past couple of weeks and had been making comments about work stress and potential restructuring at the logistics company that might affect his position, and she now understood that these comments were probably related to his fear that the affair and the pregnancy were going to become public and were going to destroy both his career and his marriage. I suggested to Nina that we should coordinate the timing of our respective legal filings and ethics complaints so that Jordan and Vanessa would face multiple simultaneous pressures that would make it difficult for them to construct coherent defensive narratives or to protect each other from consequences. Nina agreed with this strategy and said that she would file her divorce papers within the next week and that we should both submit our ethics complaints to the logistics company at approximately the same time so that the company would understand that this was a serious pattern of misconduct rather than an isolated incident that might be dismissed as a private matter between consenting adults. Before we left the coffee shop, Nina and I exchanged phone numbers and email addresses so that we could continue to share information as our respective cases progressed through legal proceedings, and Nina thanked me for being willing to meet with her and to coordinate our efforts rather than treating this situation as purely a private family matter that should be handled without involving the other affected parties. I told Nina that I believed misconduct should have consequences, particularly when it involved people in positions of workplace authority who had used their professional status to facilitate affairs that had damaged multiple families, and that I was committed to ensuring that both Jordan and Vanessa faced accountability through every available legal and professional channel. After my meeting with Nina, I drove directly to Marshall Kent's office, where I had a scheduled appointment to discuss the next steps in my separation case and to share with him the new information I had obtained about Jordan Vance's identity and his role as Vanessa's workplace supervisor. Marshall was clearly pleased to receive this information because it gave us much stronger grounds for both legal claims and ethics complaints, and he immediately began drafting document requests that would demand from Vanessa a full disclosure of her relationship with Jordan, including dates of encounters and locations and any communications they had exchanged about the pregnancy or about strategies for concealing their affair. Marshall also prepared a formal ethics complaint that I could submit to the logistics company's corporate headquarters, which had oversight responsibility for ensuring that all branch locations and all management personnel complied with company policies regarding workplace relationships and conflicts of interest. The complaint that Marshall drafted outlined the evidence Nina and I had compiled, showing that Jordan had conducted an affair with Vanessa, who was technically under his supervisory authority as HR manager. And it noted that this relationship violated the company's published ethics code, which prohibited romantic or sexual relationships between supervisors and subordinate employees, specifically because such relationships created conflicts of interest and potential liability for the company. Marshall explained that companies typically took ethics complaints very seriously, particularly when they involved HR personnel who were supposed to be enforcing workplace policies rather than violating them, and that the logistics company would likely open an internal investigation that could result in Jordan being suspended or terminated depending on what the investigation revealed about the scope and nature of his misconduct. Marshall also noted that if Jordan was fired for cause due to ethics violations, that would affect his ability to pay child support and might create additional financial pressures that would make it harder for him to avoid taking responsibility for the child Vanessa was carrying. I authorized Marshall to submit the ethics complaint to the logistics company on my behalf, and Marshall said he would coordinate with Nina's attorney to ensure that Nina's parallel complaint was submitted at approximately the same time so that the company would receive multiple corroborating reports about Jordan's behavior rather than a single isolated allegation that might be easier to dismiss or ignore. Marshall also told me that he would be serving Vanessa with the formal document requests within the next few days, and that she would be required to respond under oath to questions about her relationship with Jordan and about the paternity of her unborn child, and that any false statements she made in those responses could be used against her in court and could affect determinations about custody and property division. Over the following week, the legal machinery began to move forward with increasing momentum, as various filings and complaints and discovery requests were submitted through formal channels that created official records and required responses from both Vanessa and Jordan. Vanessa's attorney filed her response to my separation petition, in which she admitted that she had been involved in an extramarital relationship, but claimed that the affair had been primarily emotional rather than sexual, and that she could not be certain about the paternity of her unborn child without DNA testing. This response struck me as a calculated attempt to avoid making definitive statements that could be proven false while still leaving open some possibility that I might somehow be the biological father despite my documented vasectomy. Marshall immediately moved to compel DNA testing to be conducted as soon as medically safe after the baby was born, and he also filed a motion asking the court to order Vanessa to identify the biological father's name so that child support proceedings could be initiated against the appropriate party. Vanessa's attorney objected to this motion on privacy grounds, arguing that Vanessa should not be forced to identify her affair partner publicly until paternity testing had definitively established that I was not the biological father, but the judge who was assigned to our case ruled that the identity of potential biological fathers was relevant information that needed to be disclosed for purposes of ensuring appropriate financial support for the child. At the same time that these legal proceedings were moving forward, the logistics company received the ethics complaints that Marshall and Nina's attorney had submitted about Jordan Vance's affair with Vanessa, and the company's corporate compliance office opened a formal investigation that required Jordan to participate in interviews and to provide documentation of his work calendar and his interactions with Vanessa over the period when the affair had been taking place. Nina kept me informed about developments in the company investigation through regular text messages and emails, and she told me that Jordan had initially tried to deny that his relationship with Vanessa was anything other than a normal supervisory mentorship, but that he had been forced to acknowledge the truth when confronted with the credit card receipts and calendar overlaps that Nina and I had documented. The company investigation moved surprisingly quickly compared to the legal proceedings, and within 2 weeks of receiving the ethics complaints, the logistics company's compliance office issued findings that Jordan had violated workplace relationship policies and had created potential liability for the company by engaging in a sexual relationship with an employee who was within his supervisory chain of authority. The company terminated Jordan's employment effective immediately and issued a statement to affected employees saying that a member of management had been separated from the company due to policy violations, but providing no specific details about the nature of those violations in order to protect privacy and to minimize legal exposure. Jordan's termination created immediate financial pressure on his household because he had been the primary earner in his marriage to Nina, and his HR manager's salary had been supporting their mortgage and their children's private school tuition and the various other expenses that came with their middle-class suburban lifestyle. Nina called me the evening after Jordan's termination was announced to tell me that he had come home from the logistics company's office in a state of rage and desperation and had immediately tried to blame Vanessa for the destruction of his career by claiming that she had pursued him aggressively and had manipulated him into a relationship that he had tried multiple times to end, but that she had refused to accept was over. Nina said that she had listened to Jordan's self-pitying explanation with a mixture of disgust and cold satisfaction, because his attempt to portray himself as a victim only confirmed what she had already understood about his character and his willingness to avoid taking responsibility for the consequences of his own deliberate choices and calculated deceptions. Nina told me that she had informed Jordan during that conversation that she had been in contact with me and that we had coordinated our ethics complaints and our legal strategies specifically to ensure that both he and Vanessa would face consequences through multiple channels, rather than being able to minimize or conceal what they had done. Jordan had apparently been shocked to learn that Nina and I had been working together and had shared our evidence, and he had demanded to know what right Nina had to involve me in their private marital problems without his knowledge or consent. Nina had responded by pointing out that Jordan's affair with my wife had already involved me in their problems, whether I wanted to be involved or not, and that his concern about privacy and consent was somewhat hypocritical, coming from someone who had been conducting a secret relationship while lying to both his wife and his affair partner's husband. I asked Nina whether Jordan had said anything about Vanessa's pregnancy or about his intentions regarding child support once the baby was born and paternity was established, and Nina told me that Jordan had claimed he was not certain he was actually the biological father, because according to him, Vanessa had told him that she was still having regular intimate relations with me throughout the period when the affair was taking place. I found this claim interesting because it suggested that Vanessa had been lying to Jordan about the state of our marriage in order to maintain his participation in the affair, and it also indicated that Jordan was already beginning to construct a narrative that would allow him to avoid financial responsibility for the child by claiming uncertainty about paternity. Marshall advised me when I shared this information with him that Jordan's attempt to claim uncertainty about paternity would not be legally effective, because DNA testing would definitively establish biological fatherhood regardless of what stories either Jordan or Vanessa had told each other during the affair, and that once paternity was confirmed through testing, Jordan would be legally obligated to provide child support according to the standard state guidelines, regardless of whether he wanted to acknowledge the child or maintain any kind of relationship with Vanessa. Marshall also noted that Jordan's termination from his HR manager position would complicate child support calculations because his current income was now zero, and it might take him several months to find comparable employment, given that he had been fired for ethics violations that would likely come up in background checks and reference inquiries from potential future employers. The situation became more complicated several days later when Vanessa informed me through her attorney that she had decided to move out of our house and to stay temporarily with her parents, because she could no longer tolerate the hostile environment that had developed between us and because she felt that our children were being negatively affected by the tension and conflict that pervaded every interaction we had. I did not object to Vanessa's decision to move out because it aligned with what I had suggested during our initial confrontation after she received the separation documents, and because it would make the daily logistics of managing the household and the children's routines much simpler if I did not have to coordinate constantly with someone who was treating me as an adversary rather than as a co-parent. Marshall filed an immediate motion with the court requesting that I be granted temporary physical custody of our 3 children during the separation period. Given that Vanessa had voluntarily moved out of the family home, and given that I had maintained stable employment and had been the parent primarily responsible for managing school drop-offs and homework supervision and other daily routines even before the separation began. Vanessa's attorney objected to this motion and argued that Vanessa should have equal parenting time regardless of where she was currently living, but the judge ruled that given the circumstances, it made sense for the children to remain in their familiar home environment, with me as the primary residential parent while Vanessa was granted reasonable visitation rights that could be exercised at her parents' house or at other appropriate locations. This custody arrangement gave me significant leverage in the ongoing separation negotiations because it established a pattern of residential custody that would be difficult for Vanessa to challenge later if she decided she wanted to modify the arrangement, and it also meant that any final custody determination would likely default to continuing the status quo that had been established during the temporary separation period unless there were compelling reasons to make changes. Marshall explained that family courts generally preferred to maintain continuity and stability for children rather than disrupting established routines, and that my position as the residential parent during separation would be an important factor in any eventual permanent custody order. During this period when Vanessa was living with her parents and I was managing the children's daily routines on my own, I began to notice that our oldest daughter, who was 8 years old, was asking questions about why her mother had moved out and when she would be coming back home permanently. And I realized that I needed to have an age-appropriate conversation with all 3 children about the fact that their mother and I were separating and that our family structure was going to change in ways that would affect where everyone lived and how time would be divided between 2 households. I consulted with Marshall about how to handle the conversation with our children regarding the separation, and he recommended that I keep the explanation simple and focused on the practical realities of what would be changing in their daily lives, rather than attempting to explain the adult issues of infidelity and disputed paternity that had caused the breakdown of the marriage. Marshall suggested that I should emphasize to the children that both their mother and I loved them and would continue to be involved in their lives even though we would no longer be living together as a family, and that the separation was about problems between their mother and me as adults rather than anything the children had done wrong or could have prevented through different behavior. I sat down with all three children on a Saturday morning after breakfast and told them in calm, straightforward language that their mother and I had decided that we could no longer live together as husband and wife because we had developed serious disagreements that we were not able to resolve through conversation or compromise, and that their mother would be living with their grandparents for a while, and they would continue living in our house with me but would visit regularly with their mother according to a schedule that we would work out together. Our oldest daughter immediately asked whether this meant that we were getting divorced like her friend's parents had done the previous year, and I confirmed that yes, we were going through a legal separation process that would likely result in divorce, but that the most important thing for them to understand was that both their mother and I would always be their parents and would always love them regardless of what happened between us as adults. Our middle child, who was 6 years old, asked whether the separation was happening because of something he had done to make us angry or to cause problems, and I was very careful to reassure him that the separation had nothing to do with any of the children's behavior and was entirely about adult issues between their mother and me that they were not responsible for and should not feel guilty about. Our youngest child, who was only 4 years old, did not seem to fully grasp what was being explained and mostly wanted to know whether she would still be able to sleep in her own bed and whether her toys would still be in her room, and I assured her that everything in the house would stay the same for the children and that the only thing changing was that their mother would not be living here with us anymore but would see them regularly at their grandparents' house. The conversation with the children was emotionally difficult because I could see the confusion and worry in their faces as they tried to process information that fundamentally challenged their understanding of family stability and their assumptions about what their future would look like, and I found myself feeling angry at Vanessa not just for her betrayal of our marriage, but for her selfish choices that had created this situation, where our innocent children were being forced to cope with adult problems that they had no capacity to understand or control. I kept these feelings to myself during the conversation because I knew that expressing anger toward their mother in front of the children would only make them feel more anxious and would create loyalty conflicts that would be harmful to their emotional well-being. Over the following weeks, I established new routines with the children that accommodated Vanessa's scheduled visitation times, which typically consisted of weekend afternoons and one evening during the week when she would pick them up from school and take them to her parents' house for dinner before returning them to our home for bedtime. The children seemed to adjust reasonably well to this new pattern, although our oldest daughter occasionally made comments about missing having both parents in the house and about wishing that things could go back to the way they had been before, and I had to gently explain to her that sometimes adults made choices that could not be undone, and that the best we could do was adapt to new circumstances and find ways to be happy even when our lives looked different from what we had originally planned. During one of the scheduled custody exchanges, when Vanessa came to pick up the children for a weekend visit, I noticed that her pregnancy was now visibly apparent and that she was wearing maternity clothes that accommodated her expanding figure. And I felt a renewed sense of cold anger at the audacity of her continuing to carry a pregnancy that she must have known would eventually require her to publicly identify Jordan Vance as the biological father, and to acknowledge the affair that had destroyed our marriage. Vanessa avoided making eye contact with me during these exchanges, and we communicated only through brief logistical statements about pickup times and bedtimes and whether the children had completed their homework assignments, and this minimal functional interaction was probably healthier than attempting to have longer conversations that would inevitably devolve into arguments about blame and responsibility and the various ways we each felt the other person had failed to maintain the basic commitments that marriage was supposed to require. Marshall informed me during one of our regular check-in meetings that Vanessa's attorney had filed a motion requesting that the court schedule a formal mediation session where both parties would be required to attend with their attorneys and attempt to reach a settlement agreement regarding custody arrangements and property division and spousal support before proceeding to a full hearing. Marshall explained that mediation was a standard requirement in most family law cases and that, while we were not obligated to reach any agreement during mediation, the court would expect both parties to participate in good faith and to seriously consider reasonable proposals rather than simply using the mediation session as an opportunity to make unrealistic demands or to relitigate issues that had already been decided through temporary orders. I told Marshall that I was willing to participate in mediation, but that I would not agree to any settlement that required me to take legal or financial responsibility for Vanessa's unborn child, or that gave Vanessa more than the minimum custody time with our 3 existing children, given that she had been the one who had chosen to move out of the family home and to disrupt their stable living arrangements. Marshall said that these positions were reasonable and defensible, The mediation session was scheduled for a Tuesday afternoon at the family court building in a conference room that was designed specifically for these kinds of difficult conversations between separating couples who were attempting to negotiate the terms of their divorce without requiring a judge to make all decisions through formal litigation. Marshall and I arrived 15 minutes early, and we reviewed our position on each of the key issues that would likely be discussed during the mediation, including custody arrangements for our 3 children, division of marital property and debts, spousal support obligations, and the question of paternity and financial responsibility for Vanessa's unborn child that remained the central unresolved issue driving much of the conflict between us. Vanessa arrived with her attorney shortly after we did, and I noticed immediately that her pregnancy was now quite prominent and impossible to ignore, and I wondered whether she had deliberately chosen to attend this mediation session at a point in her pregnancy when her condition would be visually obvious as some kind of strategic attempt to generate sympathy or to make me feel guilty about refusing to accept responsibility for a child that we both knew I could not have biologically fathered. The mediator who had been assigned to our case was a retired family court judge named Patricia Brennan, who had a reputation for being direct and no-nonsense in her approach to separating parties, and who was known for pushing people to accept realistic settlements rather than indulging in emotional arguments or unreasonable positions that would waste everyone's time. Judge Brennan began the mediation by explaining that her role was to facilitate conversation between the parties and to help us identify areas where agreement might be possible, but that she had no authority to impose any settlement and that anything we discussed during mediation would remain confidential unless we reached an agreement that would then be formalized in court documents. She asked both attorneys to provide brief opening statements outlining their clients' positions on the major issues in dispute, and Marshall began by stating clearly that I was seeking primary physical custody of our 3 children, an equitable division of marital property that took into account Vanessa's misuse of joint funds to facilitate her affair, no spousal support given the circumstances of the marriage breakdown, and a definitive determination that I had no legal or financial obligations toward Vanessa's unborn child, who I was prepared to prove through medical documentation could not be biologically mine. Vanessa's attorney responded by arguing that Vanessa should have equal parenting time with the children, and that the temporary custody arrangement that had me as the primary residential parent should not be allowed to continue simply because Vanessa had chosen to move out of a hostile living environment for her own mental health and well-being. The attorney also argued that Vanessa was entitled to spousal support because she had been a faithful partner throughout most of the marriage and because her current unemployment following Jordan Vance's termination and the scandal at the logistics company had left her financially dependent on her parents and without immediate prospects for finding comparable work. The claim that Vanessa had been a faithful partner throughout most of the marriage struck me as a particularly bold mischaracterization of the facts, but I remained silent and let Marshall handle the response. Judge Brennan listened to both opening statements without visible reaction and then asked Vanessa directly whether she was prepared to identify the biological father of her unborn child so that appropriate child support arrangements could be established and so that we could move forward with resolving the other issues in the case. Vanessa hesitated and looked at her attorney, who nodded slightly, and then Vanessa stated for the record that the biological father of her child was Jordan Vance, who had been her supervisor at the logistics company where she had worked until recently. Judge Brennan made a note of this admission and asked whether Jordan Vance had been notified about the paternity claim and whether he was prepared to acknowledge his responsibility, and Vanessa's attorney said that Jordan was aware of the pregnancy but had been refusing to communicate with Vanessa or to discuss child support arrangements. Judge Brennan stated that Jordan's refusal to acknowledge his responsibilities was not legally relevant, because once paternity was established through DNA testing, he would be obligated to provide child support regardless of his personal feelings about the situation, and she asked whether there was any reason that paternity testing could not be ordered immediately so that this issue could be definitively resolved and removed as a source of ongoing conflict. Marshall interjected that we had no objection to immediate paternity testing and in fact had been requesting such testing since the beginning of the separation proceedings, and Judge Brennan said she would recommend to the assigned judge that testing be ordered as soon as medically feasible. The mediation continued for another 2 hours as we discussed various proposals for custody schedules and property division and spousal support, but it became increasingly clear that Vanessa and her attorney were not approaching the negotiation in good faith and were instead making demands that had no basis in the actual facts of the case or in the legal standards that would govern a judge's decision if the matter went to trial. Vanessa's attorney kept returning to arguments about Vanessa's need for financial support and her right to equal parenting time, as though the circumstances of the affair and the pregnancy were irrelevant factors that should not affect the court's analysis. And Marshall repeatedly had to point out that misconduct and deception were absolutely relevant to determinations about credibility and about what arrangements would serve the best interests of the children. Judge Brennan finally called a halt to the mediation after it became apparent that we were not going to reach any settlement agreement on the major disputed issues, and she told both parties that she would be filing a report with the assigned judge indicating that mediation had been attempted in good faith but had not resulted in resolution, and that the case should be scheduled for a formal hearing where evidence could be presented and where the judge could make binding determinations about custody and support and property division. Judge Brennan also noted in her closing comments that she found my position to be substantially more reasonable and better supported by the available evidence than Vanessa's position, and while she emphasized that her opinion had no binding effect on what the judge would ultimately decide, she wanted both parties to understand that judges generally did not look favorably on parties who made unreasonable demands during mediation or who failed to acknowledge obvious facts. The formal hearing was scheduled for 6 weeks later, which would give both sides time to complete discovery and to prepare witness testimony and documentary evidence for presentation to Judge Laura Brennan, who had been permanently assigned to our case, and who had a reputation similar to the mediators for being direct and fact-focused rather than swayed by emotional appeals or attempts at manipulation.